Joining us now is Danielle Citron, professor of law at the University of Virginia Law School of Law, who believes the outcome is, quote, a pittance for Meta. Let's start there. What do you mean by that, Professor?
You know, when Meta settled with the FTC for $5 billion over the Cambridge Analytica affair, that was, I think, something like a couple of days' worth of their advertising income. So let's just put in perspective the profits of $46 billion, I think, from last quarter or this part of this year. The first half of this year was something like $50 billion. So $17.5 billion over 10 years is a small amount of their income. It's a small hit they were happy to take.
So you are talking about the financial settlement. But for lots of people, the changes that that Meta has agreed to the Facebook and Instagram platforms are the news, right? These are significant policy changes and operational changes. So in one example, 2-hour daily limits, and it is for the parents to authorize any additional time beyond that. That brings the role of the parent into this. Is that a sufficient mechanism for enforcement?
As a parent myself, so I don't mean to demean parents. Parents are overwhelmed, they're overtaxed. And to put the burden on parents, kids are very persuasive. So if they want to override and insist to their parents, like, you can trust me, allow me to override this 2-hour limit, they're going to do it. And I think relying on parents is a mistake that both law and the Children's Online Privacy Protection Act and sort of our current lawmakers' approach, and parental control is the approach of the FTC. It's the current emphasis on current law and legal proposals. And I think it's a mistake. Parents are overburdened, and they often have their kids' best interests in mind, but kids are persuasive with kids. And for some kids, it's dangerous. So if you put parents in the driver's seat and kids are have emerging sexual orientation, they're experimenting, their gender identity, it can be quite dangerous for parents to be in total control of their social media.
I've studied the court filing for the agreement. I see no legal requirement imposed on parents to monitor, enroll in the supervision. I see an agreement that regulates Meta. Just that mechanism, explain why it will or will not work in your view.
So parents, under the Children's Online Privacy Protection Act, which is one of the series of claims in the lawsuit, it requires that parents give verified parental consent for the collection, use, and sharing of children's data, so data of kids under 13. And so in that regard, we are putting parents, law is asking parents to give permission. But as your as your news reporter just noted, kids often, they get around that requirement by putting an age for their birth date that makes them over 13. So we get around parental consent in that first way. The second is parents will often give that consent, even if kids, are honest about their birth dates. And putting parents in charge of that. So the default is under this settlement agreement that kids will have only 2 hours, so teens, and that parents can override that default. You can imagine that default will be easily overridden. Kids talking to their parents or simply doing it themselves. Hey, Mom, can I have your iPad? Right? Can I have your laptop? That is, kids are pretty persuasive. They're really smart. They carve out privacy. We know this from social science, that they do it themselves. I'm not convinced that the architectural promises made in this settlement will do very much. And unfortunately, the settlement doesn't prevent the amassing, the use, the sharing internally for Meta for their AGI experiments of this data.